This is Pat O'Connor, and I'd like to thank everybody for calling in today and listening to the presentation. I'm going to be talking today about the Paycheck Protection Program. They just passed a new law. I'm going to go to the next slide if I can. Click where here? All right, there we go. A little technical difficulty there. Sorry about that. The Paycheck Protection Program Flexibility Act of 2020. It was signed into law last Friday by the President. And here's some of the things that it changed. First, it changed the 8-week to the 24-week period. What does that mean? Under the old law, you basically had to spend the PPP loan proceeds within a 8-week period. And the 8-week period started from the date that you received the money, and you had 8 weeks from that point to spend the money on wages and certain expenses. Now, the government, Congress and the President signed a new law that says, all right, we're going to take the 8-week program and let you have up to a 24-week period of time. It's basically the earlier of 24 weeks or ending on December 31st, 2020 to calculate the use of the loan proceeds. Now, you must, and here's another change, you must use at least 60% of the loan funds, the PPP funds, for wages, or there's no loan forgiveness. So we call that a cliff in my business. So if you're at 59%, you're not eligible for any of the loan to be forgiven. You've got to pay it all back. If you're 60% or more, then you are in a position where part, or if not all of the loan, might be forgiven. The other 40% of the loan proceeds can be used for other expenses like rent, interest on mortgages, and utilities. Under the old law, prior to last Friday, there was a 2-year payback. Now they've extended the payout to 5 years. So if you have to pay back any or all of that loan, you now have 5 years to do so, and the interest rate is 1%. In addition, you can now, if you choose, delay the payroll taxes for up to 2 years. I wouldn't really recommend that. You still have to pay the FICA taxes. If you can do that on a current basis, I would recommend that you do that. Now, here's something that's sort of interesting. On Monday, the Treasury Department, in other words, the IRS, and the SBA had a joint press release where they said, look, we're going to come up with new rules and regulations, and they'll be coming out fairly soon. We'll let you know. So stay tuned. I think they're going to need to go in and refine some of the points with regards to the new law, because a lot of people are sort of questioning various things about it. And so we'll be getting guidance here, I'm guessing, probably within the next week to 10 days. Now, one of the questions I've been getting from various clients is, how does the 24-week period apply for maintaining employees? And here's something that you need to understand. You can, if you received your loan prior to June 5th, you can either elect to have the calculation be made for an 8-week period or for a 24-week period. So you have the option to say, all right, I'm just going to go ahead, since I've spent the money, I'm going to ask for forgiveness and do it for what I'd spent during the 8-week period. Or if you haven't used up all the money, then you can go up to 24 weeks. With my review of the law and from my own personal perspective, using, I received a PPP loan for my business, I'm probably going to go with the 8-week period of time, only because I want to be done with it. And it gives me a little bit more flexibility, because if I use the 8-week period, then I basically have to maintain the employees through the end of June. Whereas if I go with the 24-week period, based on what the law currently says, it looks like I'm going to have to maybe keep those employees employed for the 24-week period or to the end of the year. Now, if you elect a 24-week period, then from February 15th to December 31st, 2020, the amount of forgiveness shall be determined without regard to reduction in number of full-time employees, if in good faith you can document the following. What does this mean? I've had a number of clients say, well, gee whiz, what if I have an employee leaves? What if I can't rehire them? Blah, blah, blah. Am I still eligible for the forgiveness? The answer is yes, but you have to meet these requirements. The first one is you have to document, all right? You got to have something in writing or email or something that shows an inability to rehire those employees who were employees as of February 15th, 2020. And in addition, an inability to hire similarly qualified employees on or before December 31st of this year. So if somebody quit, and let's say that they were, I don't know, a machine operator, if you're, and they quit or they wouldn't come back to work, if you can go and hire somebody that is similarly qualified to be that machine operator, then that would qualify as, being able to sort of substitute out that employee. If you're unable to hire that machine operator and you can document that you weren't able to do that, the question is, how do you document that? Well, I suspect we're going to get guidance on that real soon. Then you meet these requirements. So inability to rehire, inability to hire similar qualified employees is one thing that the government looks at. The second thing they look at, an inability to return to the same level of business activity that businesses were operating at or before February 15th due to compliance with guidance by the Health and Human Services, HHS, CDC, or OSHA from March 1st to December 31st. So basically these entities had various sanitary or safety standards, and those sanitary and safety standards include, social distancing, things that, making sure that you have proper sanitation and so forth. All the things that we've sort of been dealing with for the last couple of months. So if you can show that, for example, your business didn't get back to the activity level that it was because of, these requirements to keep basically a safe environment for work, then again, you might be able to get your loan forgiven. And again, it's always a good idea to document that. An example of being able to do or meet that last standard, social distancing and so forth. I have a number of restaurants as clients, and restaurants, if you've eaten in one in the last couple of weeks, if you go in and they have in-room dining, usually they'll have every third table that you can sit at. So you're not able to have 100 people at your restaurant. You can only have 33, for example. So that's what that is, I guess, provided for. PPP loan forgiveness must be applied for. Just because you got the loan and just because you used the money for payroll and what have you, you still must apply for the forgiveness. How do you do that? Well, within 10 months after the last day of the covered period, either June 30th or December 31st, you have to file for the loan forgiveness. You have to fill out the little application. All borrowers must submit the PPP loan forgiveness calculation form and PPP Schedule A to your lender. So what that means is you have to submit the documentation to the person that made the loan, the bank or credit union, whoever. I would strongly recommend that you obtain help to do that, either a CPA or a bookkeeper. The form is quite lengthy, 11 or 12 pages, and it's a little bit difficult, just to let you know. Now, here's what I have found. Payroll companies, if you have a payroll company like ADP, Paychecks, or something like that, they have software and things that assist you in maybe coming up with that calculation so that you can insert the numbers on that form. Banks might also have software that might be available. Just check with your lending institution to see if they can make that available to you. Remember this though, all loan proceeds must be used during the covered period, whether it is the 8-week or the 24-week period. So whatever you don't use, you will have to pay back. The application for the loan forgiveness can be found at this email address or this site here that I've quoted, or you can just Google SBA loan forgiveness, click on a couple of things, and you'll be able to pull up the form. Again, the bank may have its own application. I've talked to a couple of bankers, and just FYI, some of the bankers are not even making the forms available until July 1st, at least for the first 8-week period of time. They don't want to be bothered with it, or for whatever reason, maybe they haven't developed the form that they want to use, or maybe they're just looking for further guidance from the SBA on this. But a couple banks that I've talked to aren't even accepting the loan forgiveness applications until July 1st. Now, some of the information you're going to need on this loan forgiveness application, and again, you can look at the application. I just pulled these things off the application, but you're going to need the SBA PPP loan number, the lender PPP loan number, employees at the time of the loan application, employees at the time of forgiveness of filing the application, the PPP loan disbursement date, in other words, the date that you received the loan. If you received an economic injury disaster loan advance amount, there's also some information you have to fill out about that. And if you did get one of those EIDL loans, you're going to need the application number, if any, and then you might have to include your payroll schedule. You might need your bank statements, your payroll records. So if you're going to be doing this, you might want to make sure you gather that prior to filling out the application and or getting with your accountant or bookkeeper about this. Now, you may be able to apply to have up to 100% of the loan forgiven. However, the SBA, we're looking for them to issue further guidance to see, what other details they've got on how the loan will be forgiven and how we calculate that. Now, one of the things that I was asked up to about a week or two ago was, what is going to happen with this loan? Am I going to be audited? Do I have to prove that this loan was necessary? And the SBA did offer guidance on that about a week and a half or 2 weeks ago. And what the SBA said was this: if you've got a loan under $2 million, you're in the safe harbor, which means they're not going to audit you. It's going to be deemed to be necessary, so you don't really have anything to worry about. If you received a loan of over $2 million, my understanding, at least what I've read and what I've garnered from other seminars that I've attended, was that you will be audited. How that audit's going to take place is anybody's guess. And just for your information, the average PPP loan was approximately $114,000. The purpose of this loan was to basically benefit small businesses. $114,000 being the average loan shows to me that it was for small businesses, and small businesses are the ones that took advantage of applying for the loan and getting the money. Now, here's something that's sort of interesting. There were two basically tranches with regards to this loan. The first tranche, I think, was for $350 billion or thereabouts. And within 14 days, all that money was gone. So Congress and the president had to sign a new law authorizing a second tranche. And believe it or not, there's about, as of this last weekend, there was about $120 billion left. I read something this morning. There was a news article that said there was about $100 billion left. So if you haven't applied for this loan, there is still time to do that. By applying for the loan, you would be subject to the 24-week payout. But it is what it is. If you need the money and you hadn't applied, I would strongly recommend that you do so while there's still money available. Use of the PPP loan proceeds eligible for loan forgiveness. Again, what we have to be cognizant of is this: you must use at least 60% of the loan proceeds for wages. Now, I had somebody send me an email yesterday, and they said, "Oh, well, gee whiz, I was told that I can't use any more than 75% of the loan proceeds for wages if I'm going to go under the 8-week." Here's the deal: you have to use at least 60%, but you can use all 100% of the loan for wages and not use any of it for any of the other expenses like the rent or the interest payment on your mortgage or utilities or what have you. The key factor to that is using it at least 60% for wages. You can use it 60% for wages, 70, 80, or even 100. Now, how do we calculate payroll costs and what constitutes a wage? Well, payroll costs consist of salary, all right, that's easy, wages, commissions, or similar compensation. It also includes payment for vacation, parental, family, medical, or sick leave, allowance for separation or dismissal, payment for certain employee benefits, like group health or health insurance, 401k or other retirement plan payments, payment of state or local taxes, which we really don't have that much here in the state of Florida. But that is what constitutes a wage. Now, what's excluded from calculation of a wage? Well, if you have an employee that makes more than $100,000, anything over that $100,000 is not includable as a wage. However, and maybe I'm getting ahead of myself, the second thing I have here is that payments for benefits like health insurance and retirement plans for a person that makes more than $100,000 can be included in the calculation. So if you have somebody that's making more than $100,000, including yourself, you can only take up to $100,000 of your wage, and you have to basically do that on a pro rata basis. With your, you have to figure out, all right, what's 8 weeks out of 52 weeks at $100,000? What does that come out to be? Or 24 out of 100? 24 out of 52. But any other benefits, the health, the 401k, and pension plans, and so forth, doesn't matter if you make $300,000 a year. Whatever you use towards that person's benefits, like health insurance, 401k, and whatever, you can include 100% of that as part of the wage. Now, payroll also does not include non-U.S. residents' salaries in excess of $100,000. Federal employment taxes imposed or withheld between February 15th and June 30th or December 31st. Now, I want to talk about this. This is basically dealing with FICA and what have you. I think we're going to get some guidance from the SBA. And I think the guidance we're going to be getting from the SBA is this. When you applied for the loan, you were able to add into the wage calculation for determining your loan the employee's FICA and withholding. Now they're saying, well, maybe that doesn't apply with regards to the forgiveness. I suspect that when the SBA issues their guidance here real soon, that we might get some clarification on that. Independent contractors also have the ability to apply for PPP loans. So any payment that you make to an independent contractor does not count towards the wages or the expense portion. In other words, it doesn't apply towards your loan forgiveness. Eligible non-payroll costs eligible for forgiveness consist of. All right, these are the other expenses that you can spend the other 40% on it if you so choose. Mortgage obligations, but it's only the interest portion of the mortgage, for example. Rent. So if you've got a lease that was in place prior to February 15th, any rent payment that you make is considered an expense item. Covered utility payments. All right, what is a covered utility payment? Well, electricity, gas, water, that's easy. Transportation, which is sort of an interesting one. Telephone and internet access. So as long as that was in service before February 15th, you can include those items. Ineligible non-payroll costs must be, again, paid during the covered period in order to be eligible for the 40%. In other words, you need to have paid the rent. You need to have paid the utility. You needed to have paid, the mortgage payment and so forth. So I just want to highlight some of the more important things. Keep in mind, one, terminating or laying off employees due to COVID-19 may decrease your loan forgiveness amount, okay, because you're not paying them out. There are exceptions to that. We covered those exceptions. For example, if they didn't want to come back, you couldn't hire a replacement, or you had a reduction because of following sanitation guidelines, the social distancing and what have you. So rehiring or bringing back laid off employees will help to increase the loan forgiveness amount, as well as making a good faith written offer. Again, you're charged with documenting this stuff. And what kind of documentation do we need? Again, we won't know until the SBA either gives guidance or we actually have to go through some of these audits. But whatever documentation you can put into place, emails, letters, whether it's certified, FedEx, or whatever, showing that you made that attempt is I think what you're going to need to do. You need to keep that in a file, make sure it's date stamped and so forth. And emails are easy to be date stamped. When you send somebody an email, it shows date and time. But I think you might need to even do a little bit more, whether it's a certified mail or something like that. If you do not use at least 60% of the PPP loan proceeds for wages, then the loan will not be forgiven. I can't stress enough how important it is that if you're going to do this, make sure that you use at least 60% at a minimum for wages. And last but not least, you must apply for loan forgiveness. Don't think that just because that's spent and so forth, I don't have to do anything. No, you have to actually affirmatively fill out that application, give it to your lender, and ask the government for loan forgiveness. Otherwise, you're going to have to pay it back over a 5-year period. The interest rate's 1%, which isn't that big, but why pay something back when you don't have to? So that's the PPP presentation. I do want to spend just the last 7-8 minutes that I've got left with you guys and talk about asset protection, because this is a topic that I've had a lot of conversations with a lot of my clients, because let's face it, a lot of people's businesses are down, and having not really been able to operate at full capacity for the last 2 or 3 months has caused some hardship for some people. So how do you protect what you've worked a lifetime to earn? And I need to stress this up front. If you're going to do any type of asset protection, you have to do it before anything bad happens. Because if you do it after you're sued or after somebody makes a demand, then the asset protection that you start to do can be unwound and those assets can be grabbed by your creditors. It's called a fraudulent conveyance with respect to creditors. And that case law is alive and well here in the state of Florida, and courts will go in there and unwind what you tried to do, and your assets are at risk. So if you're going to do anything, do it up front, do it now, do it when you don't need it. Now, what assets are protected? I just want to go over just basic stuff right now. Cash value life insurance is protected. Annuities, protected. Retirement accounts like IRAs, 401ks, protected. Your house, which is your primary residence, is protected. Joint tenants by the entirety. It's a special designation between husbands and wives. If you have a joint account, let's say at Merrill Lynch or Raymond James or wherever it's at, if you have the account and it doesn't say joint tenant by the entirety, close the account, open a new account that day one's joint tenant by the entirety. What is that? It's a joint account by husbands and wives, pure and simple. But by doing that, if one of you is sued, let's say the husband is sued because he signed lines of credit down at work, the business has gone out of business, and now the bank's coming after him on the line of credit. Well, if you've got an account that's joint tenant by the entirety, the bank can't get that asset. So it's a very common technique. Irrevocable trusts, be careful there, but certain types of irrevocable trusts are protected. 529 plans, which are savings accounts for college for kids, is protected. Head of household, certain things there are protected. If you're head of household, your wages can't be garnished. And there's certain types of corporations and entities, LLCs and LPs. And I want to sort of talk real quick about the first 4 or so that I've got on this page. Cash value life insurance. It's a wonderful vehicle for purposes of saving money. A lot of people have retirement accounts, but with retirement accounts, you can only maybe put away a few $1,000s each and every year, and it builds up over time. And if you've got a lot of money in there over time, that's great. But if you've got a situation where it's like, oh gosh, I need to protect what I've got, and I've got to do it very quick with a lot of money, take a look at maybe doing either cash value life insurance policy or an annuity. Or if you've got your house and it's got a mortgage on it, pay your mortgage off. What is JTP and how to use it? I just basically went over that, but I'll go over it again. It's married couples. Account must be set up initially as a joint tenant by the entirety account. If one spouse is sued, it's a protected account. One thing at the bottom here. Do not, I repeat, do not own your automobiles jointly. Why? Husband drives car, runs over person, husband sued. All right, the joint tenant by the entirety asset is protected. Now, let's just assume that, all right, husband's driving car, but the car is jointly owned. Well, the husband gets sued. That's easy because he's driving the car. But also the owner on that car also gets sued. And if it happens to be the spouse, both the husband and the wife get sued. Now your joint tenant by the entirety assets are at risk. So never own your automobiles jointly. Whatever car the husband drives primarily should be in his name. Whatever car the wife drives primarily should be in hers. How do you protect yourself if you're driving each other's car? get an umbrella policy, which is also known as an excess liability policy. It's insurance that sits on top of insurance. And it's basically the cheapest form of insurance known to man. For a few $100s, you can maybe get $1 million worth of coverage per year. For a few $100s more, you maybe get $2 million. I recommend a $2 million policy. Corporations. If you have an LLC, that's good. I like LLCs because they're a little bit more protected. If you've got an Inc., and a lot of my clients that have older entities tend to be Inc., it's real important that you look at how the stock is owned, really in an LLC and also on an Inc. Normally what I do is I'll sit down with a client and I'll say, well, who are the shareholders? Well, my wife owns 50% and I own 50%. Don't do that. Do joint tenant by the entirety, especially on the Inc., because with an Inc. stock, and this is real important, if I sue the husband because of the car wreck, he runs over me, for example, I can go after his assets. And I can go after his Inc. stock that basically is his business. But if it's a joint tenant by the entirety, guess what I can't do? I can't get that stock. So take a look at how your stock is owned. And also, here's another thing. You know, if the wife and the husband both own the stock 50%, when the first spouse dies, we have to probate that dead spouse's stock. So 50% of the estate or 50% of the company could be tied up in a probate. Whereas if it's joint tenant by the entirety, it passes automatically to the surviving spouse. So there's a lot of advantages here for doing joint tenant by the entirety with regards to businesses. If you've got rental property, you really should think long and hard about putting the rental property into an LLC. It's a wonderful way of owning it. And if something happens on the rental property, you have that insulation where if somebody gets hurt on the rental property, yeah, okay, the company gets sued, but you're protected. Assets are protected. And with an LLC versus an Inc., this is why I like LLCs so much. If I sue somebody that has Inc. stock, I can grab their stock. I can't grab LLC stock because the law doesn't let me do that. So that's another advantage of having an LLC over an Inc. Anyways, that's the presentation for today. If you have any questions, feel free to email me. I do appreciate everybody attending today. We finished a couple minutes early. But again, thank you for your attendance. And I hope that this presentation was helpful. And good luck. And I might be doing another one of these in the next week to 10 days, only because if the SBA comes out with other guidance, it might be helpful to allow everybody to hear what that guidance is. Thanks a lot, and God bless.